Good afternoon, everyone. Thank you for joining us for this next latest episode of HBMA Live. We had a little bit of a break after the HBMA annual conference, but today we're back with a very big and important topic for the RCM industry, the No Surprises Act, which addresses the surprise billing medical issue at the federal level. We have two special guests today to talk about the latest regulations of the No Surprises Act, and can also talk about the first round of proposed rules. We have HBMA's Director of Government Relations, Bill Finerfrock. I think many of you already know Bill. And also someone who's newer to the HBMA community, Thomas LaGreca, who's the Executive Director for Medical Recovery, Revenue Recovery at Callagy Law. So Bill and Thomas, thank you both for joining us. We're pleased to have you here today to talk about the No Surprises Act.
Thank you, Kurt. Great to be here.
Yep. Thanks, Kurt. Appreciate the opportunity. I did want to mention that many of you are familiar with my colleague, Matt Ryder, who's been the lead on the No Surprises Act. Mm-hmm. And Matt will not be joining us today, but he has a good reason. Matt is a brand new father, had a little baby born on Monday, and so he is on paternity leave. He sends his greetings, and I'd like to say that he wishes he could be here, but I think where he is where he really would rather be. We appreciate you taking the time to listen to us today, and we'll have an opportunity to take your questions. But we did want to give you an update on the No Surprises Act because there was a pretty significant development about a week ago. The federal government released what is we refer to as the interim final rule phase 2 of implementation of the No Surprises Act. Earlier in the summer, the first interim final rule was released, and that covered a number of areas of the No Surprises Act. But really, this second phase, this second interim final rule, is a really big one because this gets into how we're going to resolve disputes when there is a disagreement over the amount of money that the health plan is going to pay to an out-of-network provider. And in that regard, I think just real quickly to kind of recap, a surprise bill in the context of what we're talking about is a bill that occurs when a patient receives out-of-network emergency care from an emergency care facility, an ER, for example, that is not in network for that individual, or the individual receives health care billable services at an in-network facility, but that individual provider is not in network to the health plan. So the patient makes a conscious decision or is at an in-network facility, but happens to have an out-of-network provider who's involved in his or her care. And so they're surprised when they get an out-of-network bill because they went to an in-network facility. And the No Surprises Act, which is a bill that was passed last December, removes the patient from these reimbursement disputes when the out-of-network provider is not satisfied with the amount of payment that he or she has received from the health plan out-of-network provider. It removes the patient from that dispute, and it sets up a mechanism for resolving those disputes between the health plan and the provider. And that is something that's referred to as an independent dispute resolution process. And that is the key piece of what was in this latest interim final rule. I should point out that all of this takes effect on January 1 of 2022. So about 3 months, a little bit less than 3 months from now, this entire process will kick off. There are patient protections, as I mentioned, that in terms of the patient cannot be balance bill and so forth. But what we really want to focus in on is the independent dispute resolution process. And I'm going to go over some of the initial aspects of that, and then I'll turn to Thomas to perhaps elaborate on that a little bit and what some of your options might be. But when you have an out-of-network situation, and the provider has received a payment from the plan or an indication of what that would be, the provider or the health plan can seek to have that payment adjusted. based on this resolution process. So more than likely, it's going to be the provider who seeks to say, hey, what you have paid me, I'm not happy with. It's not adequate. It's not sufficient. I want more for my care. And so the provider, once this initial interaction has occurred, has 30 days to, and determines that they're not satisfied. They have 30 days of what is a negotiated period. The provider can reach back out to the plan and say, can we come up with something different to try and work this out? And they can do that. But at the end of that process, if the provider is not satisfied with the payment, the plan has to make a payment to the provider. They cannot keep this in a no-pay situation. They have to at least make an initial payment to the provider. And then the provider has 4 days from that point to trigger this independent dispute resolution process to try and determine a different reimbursement rate. And you can continue to have negotiations, discussions throughout this period, but you do have a specific window of time in which you need to trigger this independent dispute resolution process. And it is what is referred to as a baseball style process. Each side to the dispute will put forward an amount that they believe is reasonable in terms of payment, and it will be up to an arbitrator to decide how much the individual is going to, what of those the individual provider is going to get. And the arbitrator can only pick from the amount that the provider has requested or the amount that the health plan has offered. They can't, split the difference or come up with a different amount. And so this, as I said, these new rules really go into what this process is going to entail as far as how this will get resolved. And to be honest with you, we're not particularly happy with how this process came out in terms of this interim final rule. An interim final rule, by the way, means that it is essentially a final rule. Although the public has the opportunity to comment, it is a final rule and is not following the normal rulemaking process because the deadline for implementation of the law is January. They can't use a full-blown notice and public comment process. But one of the issues that was at hand is there a starting point for this discussion with the health plan? And one of the issues was what would be referred to as the qualifying payment amount. And HBMA and others had been arguing that if there's going to be a qualifying payment amount, it should be as high as possible. And CMS, HHS in this process did not do that. They chose to have the qualifying, what is referred to as the qualifying payment amount, is the lesser of the billed charge or the plan's median contracted rate. So for all intents and purposes, in the vast majority of instances, your median contracted rate is going to be that the default payment rate, if you will. And then you can come in and ask for more than that. The plan can say, nope, that's what we want to pay, or we want to pay less than that. But that is this QPA, or qualifying payment amount, is going to be the foundation, the base rate from which everything else is going to be determined. Let me stop there. And Thomas, would you like to add anything or put anything in before we go on in any more detail about this?
Yeah, I'd be happy to. So the No Surprises Act at the federal level, like the laws that have been passed over the past 4 or 5 years at the state level, is aimed mainly at patient protection from getting a big out-of-network balance bill, and everybody applauds that, right? So the sticking point basically comes down to what the reimbursement scheme will be for purposes of the out-of-network provider, because there's no agreement between the carrier and the provider. You can't pay the provider on the plan's out-of-network, on the basis of the plan's out-of-network provisions, because if the provider can't balance bill the patient, then they're being mistreated if they're paid at the out-of-network standard in the plan, because the balance bill is part of the out-of-network reimbursement scenario typically. So everybody applauds the patient protections. The question comes down to, as you noted, Bill, is, and the devil's in the details, as to what the arbitration process will look like, and what the standard of reimbursement will be. And I hate to say it, but there's a lot of open questions even after this set of interim rules has been put out, in terms of what exactly that reimbursement standard is going to look like. Without getting into too many details at this moment, there seems to be a tug of war going on between giving some deference to what the states in their surprise bill laws are doing, and to give an emphasis on the QPA, which, as you mentioned, is based on the standard, the median in-network rate. So, for us that operate in the space of out-of-network recoveries, the notion that the out-of-network provider is going to be reimbursed at a median in-network rate is essentially saying to the out-of-network provider, we are forcing you to be in-network. So, there's a lot of tension there. So from at least my perch, we'll be looking for ways to at least have the results reflect that it is an out-of-network provider and not simply an in-network, and that an in-network rate, even if it's a median in-network rate, is not really where we want to end up. So how I'm going to do that, I don't know, but the wheels are turning.
Yeah, and I think this qualifying payment amount, and as you point out, and I think that's the really nasty part of it. It really strengthens the hand of the plans in terms of either, if they say, well, look, we're only obligated, we're gonna pay the median in-network rate, you might as well join our network, and then you don't have to worry about all this stuff. Now, sometimes that's not an option. Sometimes even when you want to join a network, they don't allow you. They'll tell you, well, we're full. We're not accepting any more providers. You should have joined sooner. But the bottom line is, we feel that this process is really going to, kind of tie you to that median in-network rate. Now, it's not set in stone, right? The arbitrator can pick a rate. You do have the option and the opportunity to provide information to the arbitrator, who can then determine that you have justified that you should be paid more. Now, there's specific information that the arbitrator can consider, and so it's going to be important for HBMA member companies when you have a situation where you want to challenge, that you have access to that information. And so some of the things are the training and experience of the provider. So in an ER, for example, are the ER docs board certified ER physicians versus an internal medicine physician who's covering the ER, or a physician from some other specialty who's covering the ER? And the ER physician board certified may say, well, look, your in-network rate reflects a range of different specialties, and I'm an ER trained physician. I deserve to be paid more because I'm board certified as an ER physician. But they can look at that educational or experiential difference. What market share does each party control? Is it a situation where the health plan is the dominant payer in the market, and therefore is exercising undue pressure by virtue of their market size in order to try and force down prices and create a non-competitive? Or conversely, is it a situation where the ER group has a larger percentage of the market and therefore may feel obligated or entitled to higher payment? What is some of the previous contracting history between the plans? We've heard stories about a situation where specialties are like, oh, we've been in network for this provider plan, and then they just recently told us that they're dropping us from the network and they want to renegotiate. Well, are they coming back because of the legislation and saying, hey, look, we only are going to have to pay you the median in-network rate. We were already paying you for the last 5 years. We've been paying you at a rate that's 20% above that. we now see the No Surprises Act as an opportunity to lower what we're paying you. And so we're going to cancel the contract, force you into an out-of-network, and then force you basically to accept the median rate rather than the higher rates. Well, you can come in and show the arbitrator that, hey, wait a minute, guys, they've consistently paid us, at this higher rate. They're trying to game the system, and that can be taken into consideration. And there are other factors as well. And these are the kind of things that somebody in Thomas's group would probably bring to the table, would ask the arbitrator to consider as part of a challenge to a rate situation. Have I kind of fairly reflected that, Thomas?
Yes, and yeah, so absolutely, Bill. So the arbitration process, as you said, the rules articulate what additional factors can be considered, what additional factors cannot. There are a number of items that can be brought to bear in the arbitration to get the QPA moved in some way, or to show that the QPA somehow is not reflective of what the reimbursement should be. The interesting part, and I don't know how this is all going to play out, but the way it's framed, before you even get to the QPA, they state that if there is an all-payer model agreement, a state all-payer model agreement, or if there's a specified state law regarding the reimbursement, that's what the reimbursement will be before you even get to the QPA. So the QPA is the fallback, in a sense, if the state doesn't specify a standard of reimbursement. Now, that's really interesting because some states apply a percentage of Medicare. So it's a very specific articulated standard of reimbursement in their surprise bill laws. But a number of other states base it on reasonableness, right? It has to be a commercially reasonable rate, or there's a reference to other reasonableness type of terminology for their standard of reimbursement. So now I find this very interesting because I would certainly argue that in a state like New Jersey or Florida or New York or Texas, which are founded on the notion of reasonableness for their state surprise bill reimbursements, that should be considered a specified state law, no different from the states that say it's going to be 200% of Medicare. So I don't know if that argument will prevail, but certainly the initial argument to be made, I think, at least if you're dealing with treatment in a state that has a good standard of reimbursement for the practitioners and the medical facilities, that would be the first line of argument. If that fails, then you're into the QPA debate and whether the QPA is satisfactory or not. So there's kind of a two-pronged approach. Now, the interesting thing too is specifically the arbitrator is not supposed to be considering UCR, usual and customary, right? But
or Medicare or Medicaid rates.
That's right. Yet, if a state has a standard that's tied to Medicare, I assume it falls under that preliminary standard of reimbursement before you even get to the QPA. And a lot of these states that are based on reasonableness, they do look at some definition of UCR, whether that's an independent database of payments, et cetera, et cetera, et cetera. So there's kind of this little bit of a tension, I think, and that's why I mentioned there's a tug of war between some sort of deference to the states and the preeminence of the QPA and how exactly that's going to play out. I think it'll be interesting and hopefully financially beneficial to the medical community.
So Thomas, what I'm hearing is, despite the fact that this is a national law to try to create a national, uniform standard, there'll be a lot of variability state to state, or likely to. And that may be a surprising outcome of this. So it never was meant to interfere with the states that have a comprehensive
set of protections for the emergency patient from the balance bill. So, the law always said, look, if the states have their own comprehensive surprise bill law, this is not going to interfere with that, at least with respect to the state regulated plans in those states.
Right.
So those state laws never applied to the federally regulated plans, such as the ERISA plans. So I find it interesting that they kind of said, hey, not only they kind of opened the door, and Bill, you might disagree or agree to varying extents, but they kind of opened the door to even determining that the ERISA plans or the federally regulated plans may even somehow, there may be some deference to how those states try to reimburse. And I'm kind of hoping that's the case.
Yeah, I think you're right, Thomas. I mean, I think it's an interesting situation where, as you've laid it out, if they are going to say in those states where you have a comprehensive law that is, we're going to essentially defer to that. It could be that where the ERISA plan now, if you want to create if you have a dispute, they're going to say, well, let's look and see what the state law applies. And so even though ERISA is exempt from state law, this No Surprises Act kind of gives you a backdoor way of getting the state law. And so if the state law is better than this QPA IDR process, you may want to try and exercise or pursue that as a legal strategy to say that. Now, I think the all-payer reference, I think, is a unique Maryland situation. I think Maryland is the only state that has an all-payer. But you're right, the other language that's there with regard to a comprehensive state law seems to open the door here for this opportunity to get a backdoor application of state law to ERISA and ACA plans. But that's going to be something that's going to have to shake out over time, I think.
That's right. And I have no doubt that the carriers are going to point to the state laws that pay a percentage of Medicare. And they're certainly going to argue that in those states do have a specific standard of reimbursement. So,
right.
And I hope they make that argument, because that'll enable me to make the counter arguments in the states that do have good reimbursement.
So this is the Lawyers Full Employment Act.
Leave it to Washington to make sure the lawyers always stay busy, right?
Yeah.
Well, as a lobbyist, we'll look out for the lawyers if the lawyers start looking out for the lobbyists. So
there you go. So Bill and Thomas, once these decisions start coming down, would they be public? How does Congress, does industry, how does the public just assess, how these are turning out, and assess if there are patterns in various states or maybe for specific types of claims and disputes?
Well, I can, Thomas, you can weigh in. I mean, my sense is that, certainly people are going to know how these come out, right? And you may have a situation where over time, people will, you're kind of gravitating to the middle, and it may be less and less desirable to challenge these, because the outcome is almost going to be known ahead of time. You're going to look at the track record and say, look, these cases in this state, these challenges have occurred. Every time it's been challenged, they default to the QPA, because there is a cost to this, right? This isn't a free process. And so, that's the other thing that you have to weigh in terms of whether or not you want to challenge is, okay, if I lose, I'm going to have to, I have to pay to challenge this. And so I think you will have a situation where people will say, you know what, it's just not worth it. And again, you're going to end up with that median in-network rate essentially becoming the default. And then it's either, okay, you can join the network, this is what you're going to have, or you can't join the network, and this is what you're going to have. And the notion of negotiation and success at an alternate over time may dissipate. Yeah.
And I think in terms of how, the decisions being public, Kurt, I think they're definitely going to be publicly available. Now, how easy it is to be able to search and obtain those may be a different question. Depending on the state, some arbitration decisions, even though they're considered public, may not be readily available just from searching their website or whatever. So I think that kind of remains to be seen. But they will be publicly available. How readily available is probably another question. Yeah.
So that's a real challenge for the industry moving forward, just to assess the trends. Another challenge I see is just the time frame. So 4 days to trigger the dispute resolution process. That's not a lot of time. And do we know what that application's like? Do they just need to say, hey, I want to, dispute this, or do they actually have to put forward a full argument against the initial reimbursement rates when they submit?
There is. I would imagine there's going to be some mechanism for a formal form. I don't believe that exists at this point. Unless I missed it, Thomas. Is there any indication of what the mechanism will be for formally challenging?
Yeah, basically they said all the filings will be through a federal portal. I am sure there will be some level of forms that are going to be standard to be filled out,
right?
Probably with an opportunity to supplement the form with, some argument of your own making, that sort of thing. And most of the states that have these, it is a mix of the two. So there are certain forms to be filled out, and then there's an opportunity to make more detailed arguments and attach them to the submission. So I think that's what we should expect, even though I don't think it's really been fully addressed yet, as Bill said.
Okay. Yeah, and I think too. I mean, the filing is 4 days. I think it would be shocking if the scheduling of the dispute or the request for information, there's going to be a time lag. You're going to have to assign an arbitrator. You're going to have to set up. So, I think during that 30-day period when you're in dispute, I think you want to use that time to collect the information, to have that. But we'll see what the time frame is. Go ahead. Did you have another question, Kirk?
Yeah, we have a question that came in, but that's just before I ask that, that's a great point too, Bill. Do we have any sense how long this whole dispute resolution process is going to take? Is it going to take 30 days? Is it going to take 60 days, 90 days, or is that just another unknown at this point?
Thomas, do you want to address that?
Sure, I'll be happy to. So the 4-day time frame is really incredibly tight. I mean, that from the beginning, I thought it was a typo when I first saw the legislation back in 2020. I couldn't imagine that they were actually going to be talking about a 4-day. Now, and keep in mind, the 30-day negotiation period has to run. They don't want you filing prior to the running of the 30-day period. So that 4-day period literally is between day 30 and day 34, which is, I mean, for even the most effective processes, that's incredibly tight. So,
Thomas, does that mean it's calendar days and not business days as well?
Well, they do make a point to say it is business days unless the term calendar days is used specifically. So these are business days, which gets us, I think, a little bit of more wiggle room, but still pretty tight. It doesn't get us much. Yeah. So in terms of the overall process, so you have to send the letter requesting negotiation to the carrier within 30 days of getting the EOB. So there's 30 days there. Then you have the 30-day negotiation period, which puts you at 60 from the EOB date, right? Then you have 4 days to file the arbitration. There are some other timelines in there, I think 10 days, 3 or 6 days to pick an arbitrator, then 10 days for the arbitrator to get papers in, and then 30 days for the arbitrator to make a decision. So you're probably looking at, I would say, 120 days of process from the EOB date to when a decision gets rendered, and then you're probably, and then the payment is going to be shortly thereafter. So you're probably looking at somewhere around 120 days, I think, from front to back. The other interesting thing, Bill, and you'll appreciate this for its lack of clarity, I think. So there's this 90-day timeout that's called for if you're arbitrating against a particular carrier. So you look at the 30-day requirement, the 4-day requirement, and then a 90-day timeout, and you say, wait a minute, how is the 90-day timeout going to jive with all of these other tight timelines, right? Mm-hmm. So if you bring an arbitration against a particular carrier on when you went through you followed all the timelines, the 30 days, the 4 days, so once you file that arbitration, presumably you can't file another arbitration against that carrier. And I think it's framed in terms of 90 days from the rendering of the arbitration decision. I think it's framed that way. Now, if that's the case, if you have 90 days or 120 days of arbitration pending, then tack another 90 days for the timeout, I mean, you're out. You can't arbitrate against that provider, against that carrier for 6 months, conceivably.
I thought it was limited to the same service. So in other words, let's say I've got a total knee and I'm arbitrating the payment on a total knee, and then I have a total hip. Right. I'm not precluded from arbitrating the total hip because I've challenged the total knee. I'm only precluded from challenging a total hip again immediately after I arbitrate. I have to wait 90 days specific to the actual service that's in question.
Yes, you're absolutely right. So in the surgeon context, it's not such a problem. But take, for example, an intraoperative monitoring provider, right? So they bill, they monitor the patient's vitals and things during a spine surgery.
Right.
And they tend to bill the same 5 or 6 CPT codes.
Correct.
Right? Because it's the same monitoring pretty much from patient to patient. So if I'm an intraoperative monitoring company, I may do 10 of these a day at a particular hospital, or my team may do 10 of these a day at a particular hospital, all the same CPT codes, all involving the same carriers, and that particular specialty tends to be out of network. So they may be, they can probably, once they file one of these, they're expected not to be filing anymore against that carrier for months. These are things that, depending on this, I think when they wrote these, they're thinking in terms of a surgeon, but there's a whole host of medical providers that are subject to this that are going to be adversely affected in a different way.
Yeah, and I think that example is spot on. I know we've had some conversations with some of the folks in that specialty, and they're very, very concerned about the No Surprises Act. And some of these issues.
Tie into the question we got too. So let me read this, and you may both be able to see this as well. So we got a question from Jonas Heinrich. If an inpatient radiology group goes out of network with BCBS, there may be 40 claims in a given day. In a dispute situation, each of the 40 individual exams be disputed or will be batch style. And I understand they can be submitted in batches.
Yes, you can batch them.
Yeah. So that will at least help a little bit, but it doesn't help that cooling off period that you've both been talking about, which could be extensive.
Yes.
Yeah, and I think it's going to depend on the specialty, and but again, I think we don't know what the fees are going to be, but there's a $50 filing fee, but then there's a fee that will be paid by the independent dispute resolution, the arbitrator, and that fee can vary. And the losing party will have to cover the cost of that. And I mean, maybe you do, Thomas. I have no idea what those folks charge for their services, but that could have a chilling effect on the desirability of challenging particularly soon. So if you file and then 30 days you were to file again, you lose your case, and now you have to pay the fee. Are you now looking at, okay, what new information? So you may want to self-regulate in terms of how frequently you're filing till you get a sense of how this process is going to shake out. Do I have a reasonable prospect for winning? Because if I don't win, not only am I not getting the money I wanted, but now it's going to cost me. Do you have a sense of what those fees tend to be like?
It could be. It's likely to be several $100s. Okay. So, and I'm using the states as a gauge of this. Some of the states are more reasonable than others because I think they are, at least a lot of the states that have passed these seem to be more sympathetic to the medical community and giving them an opportunity to be heard than I'm getting a sense at the federal level. Mm-hmm. For some reason, my gut is telling me that at the federal level, they're trying to, they're looking to emphasize through the median in-network rate, they're trying to move things in that direction, and that they may very well be pricing, the arbitrators may be priced in such a way to discourage arbitrations. So, yeah, I mean, it's very possible that it may look even worse than a few $100s to arbitrate, which is what we're seeing at the state level.
Okay.
Well, Bill, you might have identified the next no surprises billing legislation that's needed. That's one to actually have a dispute resolution process for the arbitrators' fees themselves. So
we're always looking for new legislative ideas.
There you go. So hey, you heard that first here on HBMA Live. So look out, arbitrators. No, but thank you both for being a guest today. And I think this has been really insightful to just help explain what's happening, because there's a lot of unknowns, and there's not a lot of time to actually get up to speed with us with the January 1st implementation deadline, and a lot of questions still to be answered. So
and we've tried to put out some of the summaries up on the HBMA forum, in the HBMA newsletter, and we'll be putting more out as it becomes available. We'll probably be looking to schedule an end of year webinar sometime in December, where we'll be able to go over some of this stuff again and some of the other legislative and regulatory actions that have occurred this year. But if you do have questions that we didn't address or you didn't want to raise here today, feel free to reach out to us individually, me or Matt at for HBMA. Thomas, you're a private practicing lawyer. I don't want to create an expectation for you, but
no, not a problem. I'll be more than happy to answer any questions anybody has. More than happy to.
Okay. Yeah. Well, and I think most people know how to get hold of me. So.
Yeah. Thank you both. And thank you everyone for tuning in today to hear about this really important topic for the industry. So everyone stay safe, be well, and we'll see you again for HBMA Live soon. Take care.
Great.
Thank you guys so much. Thank you, Kurt.
Yep.
Thanks, Bill.
Be well, Thomas. All right. Thanks. Bye-bye.